Advocate General for the State of Goa, Devidas Pangam, retired judges, President of the Goa High Court Bar Association, Zail Mano Coelho Pereira, learned senior advocates, my fellow colleagues, and their students. On behalf of the Goa High Court Bar Association, I extend a warm welcome to all of you to the second H.R. Khanna Memorial Lecture. The H.R. Khanna Memorial Lecture Series has been instituted to honor the life and legacy of one of India's greatest constitutional jurists, late Justice H.R. Khanna, whose unwavering commitment to judicial independence, constitutional morality, and the protection of civil liberties remains a beacon for the legal fraternity. His courageous dissent in the landmark decision of ADM versus Shivkant Shukla, affirming that the rule of law and the right to life and personal liberty cannot be extinguished even in times of emergency, stands as one of the defining moments in India's constitutional history. Justice H.R. Khanna's enduring legacy is perhaps best encapsulated in his timeless observation that without such sanctity of life and liberty, the distinction between lawless society and one governed by laws would cease to have any meaning, a principle that remains at the heart of our constitutional democracy. It is this enduring legacy of safeguarding constitutional freedoms that this lecture series seeks to celebrate. The inaugural lecture series in this was delivered by Honorable Mr. Justice Obey Oak on the theme The Independence of Judiciary. This evening, we continue that tradition with another distinguished jurist, Honorable Mr. Justice A.P. Shah. I request the learned senior advocate Mr. Coelho Pereira, President of the Goa High Court Bar Association, to deliver the welcome address.
Sorry for this. Honorable Mr. Justice A.P. Shah, Mrs. Shah, Honorable sitting and retired judges of this court were present. Honored Advocate General of State of Goa, my senior and junior colleagues at the bar, dear students of law, and members of the audience. At the outset, let me profusely welcome and thank Mr. Justice A.P. Shah for having accepted our invitation to deliver the second edition of H.R. Khanna Memorial Lecture. We are all honored and privileged to have you, sir. We began this lecture series with the erudite lecture, as my junior colleague told here, by Mr. Justice Abayok, and the inauguration was at the hands of Mr. Sridharan Pillai, who was then the governor of Goa. This year, we have you, sir, to address us on a topic of relevance, which you chose as a topic of your dissertation. Guardians of the Republic, the judiciary's role in protecting civil liberties. That's your theme. Sir, the topic attains importance for two reasons. The first is that it brings to our recollection the fact that Justice H.R. Khanna always stood and perceived the independence of judiciary as no privilege conferred upon the judges, but a secret trust reposed by the people to deliver justice within the framework of the rule of law. And secondly, because of the recent happenings in the course of the students' agitation on the issue of NEET paper leak. Mr. Justice A.P. Shah is known to many of us, at least the seniors present here, who had the privilege of appearing before Mr. Justice Shah when he sat here and delivered justice within the framework of what Justice H.R. Khanna professed and practiced. The intervention of the judiciary in safeguarding the liberties of a citizen is, as of today, the need of the hour. The Indian judiciary does not lack persons of courage and conviction. I may mention the recent judgment of Mr. Justice Jamdar of our High Court in the case of Sayyid Ahmad Abdul Wahid Chowdhury, where without fear and with blindfold eyes, his Lordship rendered a bold judgment upholding the right of dissent. Having said this, I don't want to detain you further, as you all must be eager to hear Mr. Justice A.P. Shah, who has obliged us and has come all the way from Pune, leaving behind his busy schedule, which he still has after retirement, to tell us his insights and experience as a judge. Thank you.
I now request Advocate Caroline Colasso to introduce our distinguished speaker.
Honorable Mr. Justice Ajit Prakash Shah is one of India's most respected jurists and a champion of progressive constitutionalism. Honorable Mr. Justice Shah served as a judge of the Bombay High Court and later as Chief Justice of Madras and Delhi High Courts. He delivered some of the most prominent judgments ranging across diverse issues. We all remember the decriminalization of Section 377 verdict, but there were others that were equally memorable. Applicability of RTI to the office of the CJI on issues of environment and ecology, protection of disabled persons, laws related to women, child labor, contract labor, slum dwellers, HIV affected persons, amongst others. What set him apart, though, is his extraordinary and consistent sensitivity to the rights of the poor, the weak, and the marginalized. After his retirement, he headed the 20th Law Commission of India from 2013 to 2015, which submitted a total of 19 reports, including on electoral reforms, eliminating discrimination against persons affected by leprosy and the death penalty. His reports on commercial courts and amendments to the Arbitration and Conciliation Act have been accepted by the government and was enacted into law in 2015. He is also served as a member in the expert committee of the International Labour Organization for implementation of the ILO conventions by member countries from 2014 to 2016. He is also nominated as a commissioner in the International Commission of Jurists. He has been associated for long with many non-governmental organizations and movements across the country, as well as participated in people's tribunals on various human rights issues in India and abroad, including communal rights in Delhi and Kandhamal. He has served on the Ethics Committee, advising various bodies such as the Bhabha Atomic Research Center, as well as many national sports bodies. The void he left behind on his retirement was indicative of the fact that marking his retirement as Chief Justice of the Delhi High Court, an umbrella of more than 15 human rights organizations, representatives of people's movements, and academicians got together to celebrate not just him, but the inspiring legacy he left behind, which will, and Justice Shah will remain a beacon for the judiciary in this country to emulate in the years to come.
Hello, check.
I now respectfully invite Honorable Mr. Justice A.P. Shah to deliver the memorial lecture.
A very good evening to Mr. Coelho Pereira, President of the Goa High Court Bar Association, the office bearers of the association, distinguished members of the bar, the bench, and ladies and gentlemen. Thank you for the invitation to this memorial lecture in the name of a judge whose name will forever be etched in the memory, as synonymous with the idea of constitutionalism and the rule of law. It is sheer coincidence that just around the time I received the invitation, I also picked up a copy of Justice H.R. Khanna's autobiography, Neither Roses Nor Thorns. The book basically contains his memoirs and is told in clear and simple language. What fascinated me was the many insight it contained about the ideas and values that shaped his judicial career. For me, Justice H.R. Khanna's legacy is a personal memory. I joined the legal profession in the early 1970s. I was a young, idealistic lawyer, but as soon as I joined, I walked into a profession in great turmoil. Many things were happening just around that time. The judgment in Keshavananda Bharati had just been delivered, and in response, the executive struck back. This was when the Supreme Court saw the first unprecedented supersession of three senior judges. Justices Shelett, Grover, and Hegde were overlooked, and instead, the Indira Gandhi government appointed Justice A.N. Ray as the Chief Justice of India, primarily because he was one of the dissenters to this judgment and sided with the government in the Privy Purses and the bank nationalization cases. As a young lawyer in Maharashtra, I saw the consequences of this firsthand when India's darkest hour, the emergency was declared. While questions of executive excellencies were there, I also witnessed the collapse of a last section of legal fraternity. So many judges and lawyers began aligning with the government, even holding conferences to praise the Prime Minister's 20-point program, which was nothing but a political tool to justify the emergency. In this background, the figure of Justice H.R. Khanna arose as a beacon of hope. Here, if you consider the historical basis for the idea of Indian Republic, especially during the Constituent Assembly's debates, our courts were conceived in an entirely different spirit. Prime Minister Nehru, to the immense credit of the executive of the day, remained deeply respectful of the independence of judiciary. Nehru consistently maintained that India deserved first-rate judges, not subservient courts. He was consistently committed to the process of nation building and understood courts must be empowered to stand up against anyone, even the state. As a result, in early decades, the Chief Justices of India were much more powerful, enjoying virtually a veto in judicial appointments, relatively unconcerned about the political influence. As Justice Patanjali Shastri memorably phrased it, the judiciary was the sentinel on the key wheel, the watchful guardian of the republic, active, vigilant, and independent. By the mid 1970s, by the time I joined practice, those founding ideals were being tested to breaking point. In midst of all this, Justice Khanna redefined the idea of the guardian and became, unwittingly perhaps, the yardstick for judicial courage. In his memoirs writing about the role of the judiciary, he wrote, the important thing is that the courts must enjoy the respect of all those who enter the precincts and inspire confidence amongst them that justice here is administered with an even hand in any legal combat between the rich and the poor, between the mighty and the weak, between the state and the citizen, and without favor and fear. Law, it has been said, knows of no finer hour than when it cuts through formal concepts and necessary emotions to protect unpopular citizens against discrimination and persecution. Indeed, this is the standard he set and lived by. While there are many aspects to this, I want to briefly touch upon three occasions where Justice Khanna's strength of character comes across in his jurisprudence and his understanding of civil liberties and constitutional democracy. The first was the Keshavananda Bharati decision. We all know and often talk about the basic structure doctrine as a huge milestone for India. But there is a backroom story that is sometimes forgotten. In 1973, the 13-judge bench was divided right down the middle. 6 judges expressed a view that there were no limitations on Parliament's power to amend the Constitution, including the power to amend the fundamental rights, while 6 others believed that fundamental rights could not be amended. In the middle was Justice Khanna. He was the one who said that Parliament could not alter the basic structure or framework of the Constitution. This proposition was included in 6 propositions listing out the view of the majority, which was signed by 9 out of 13 judges. There was a debate that even the other judges agreed with Justice Khanna, but Justice Khanna's phrasing became the law as an administrative chance, or as Palkhiwala put it, quirk of fate. And this has become the law of the land just by the way the decision has been physically signed by 9 judges. Regardless of the administrative issue, the majority position has now become final. It is arguably our good fortune that this is so, for it has led to wave of interpretations becoming a shield against attempts to alter basic structure such as judicial review, secularism, and fundamental rights. Chief Justice Dhananjay Chandrachud more recently even called the basic structure the North Star for India. The second case I wanted to mention, and this is rather important, was St. Xavier's College case. Here, Justice Khanna, in his concurring opinion, mounted a defense of minority educational institutions. He understood that secularism and minority rights were necessary prerequisites for a democracy, and civil liberties are meaningless if they do not protect minorities. This is the rationale of the fundamental rights contained in Articles 25 to 30, which preserve the rights of religious and linguistic minorities amidst political vagaries. Finally, of course, one cannot speak of his legacy and not mention ADM Jabalpur case. For context, I see many young juniors and the college students. I must tell you the context. You will appreciate that emergency was an indescribably dark period for India and Indians. The intelligentsia had been all but silenced, with thousands and thousands of people jailed for no reason. These included political opponents, activists, journalists, and many others. After emergency was declared on 26 June 1975, the following day, a presidential order suspended the rights of all detainees to enforce any rights under Articles 14, 21, and 22. Right under Article 19 was already automatically suspended. At that period, the question emerged as to whether such detainees would approach high courts under Article 226 for habeas corpus. 9 high courts, including Allahabad, Bombay, Delhi, Karnataka, Madhya Pradesh, Punjab, and Rajasthan, agreed that court could examine the orders of detention. The various state governments and the Union of India then appealed to the Supreme Court. A bench of 5 judges was constituted to hear this case. Besides Chief Justice A. N. Ray, the bench comprised Justice M. H. Payne, Justice Y. B. Chandrachud, Justice P. N. Bhagwati, and Justice H. R. Khanna. What stands out in this bench is that all the judges were destined to become Chief Justices of India for short or long terms by virtue of seniority. At the hearing, Justice Khanna pointedly asked the Attorney General as to whether any remedy was available, say if a police officer, for reasons of personal enmity, detained or even killed a man. The Attorney General, while admitting that it shocked his conscience to say it, declared that there would be no judicial remedy in such a case as long as the emergency exists. We all know about Justice Khanna's known and historic dissent. The essence of the dissent was that life and liberty existed before the Constitution came into existence, inherent in the idea of humanity itself. His dissent was eloquent, wise, and courageous, for no one else on the bench had the gumption to point out this universal truth. Interestingly, he was extremely perceptive of the consequences of his dissent. The night before he delivered the judgment, he told his wife and sister that his judgment would cost him the Chief Justiceship. The superstition followed. He also faced public isolation. He was persona non grata at official dinners. A minister staying opposite his office once invited all Supreme Court judges except him. Acquaintances avoided him at public functions, but he bore all this with grace. When he resigned, he delivered a memorable farewell address before the Supreme Court bar, which is worth reading. You will find it on the internet. What stands out for me is his reference to the symbiotic relationship of the bench and the bar. He pointed out that the independence of the judiciary does not exist in a vacuum. And the bar, in fact, is the judge of judges. He said, judges shine with reflected glory, and their reputation stands on the brilliance and fearlessness of the lawyers who argue before them. It follows that if the bar itself becomes self-sovereign or quiet, the bench will also be affected. A courageous and independent judiciary therefore requires a fearless and vigilant bar. This, ladies and gentlemen, brings me to my topic, which is the role of guardians in protecting civil liberties today. To understand this, we need to recognize the scale of current situation and consider how civil liberties are being systematically dismantled across every corner of the country. In Delhi, political dissenters remain trapped in years of pre-trial custody under the UAPA. In Delhi, while independent newsrooms face financial paralysis through coordinated PMLA or tax rates. Nationwide, journalists face anti-terror cases for reporting on state action. In Jammu and Kashmir and Manipur, prolonged internet blockouts cut off the whole population. In Bengal, mass voter list deletions have stripped people of their identity. Most worrying is the shrinking space for dissent on university campuses, where questioning authority is conflicted with disloyalty, where any critic of the state policy is automatically branded as anti-national, and where protests against unfair administrations or examination irregularities are met with violent lathi charges, FIRs, preventive detentions, and threats of suspension. In some cases, anti-terror laws like the UAPR are unleashed, with students dissenters caught in the wave of fabricated conspiracy theories and threats to national security. One cannot predict when the genuine questioning spirit of a youth may be interpreted as sedition or treason. With all this in mind, how does today's judiciary measure up? Is the guardian on this or the sentinel on vigil, or has fallen into a sort of compliance the kind we saw in 1970s? I must point out that civil liberties is a vast landscape, and there is no way I can do justice to all the freedoms granted to us. Instead, as a concerned citizen and as a member of the legal community, I wish to examine only four pillars: citizenship, personal liberty, free speech, and secularism. In my opinion, those four are the fundamental pillars. Citizenship defines who has the right to have rights. Personal liberty protects the individual from arbitrary state power. Free speech gives voice, and secularism ensures that every individual, regardless of faith, stands before the state as an equal. If these four crack, Indian constitutionalism itself becomes a peace. Citizenship is sometimes called the mother of all rights because it represents the very right to have rights. If you strip a person of their status as a citizen, all other fundamental guarantees, whether they are free speech, personal liberty, or equality, instantly vanish. Without citizenship, it is fair to say that a person effectively becomes invisible to the state. All the more reason why it is of utmost importance to protect it. In India today, there is a worry that this mother of all rights is being structurally attacked. Many routes are being used for this, whether it is the Citizenship Amendment Act, that is CAA, the National Register of Citizens, that is NRC, and the exercise of the Special Intensive Revision of Electoral Rolls, that is SIR. When there were agitations and protests against the CAA, the Supreme Court said that it would take up the matters after this protest ended. Therefore, Chief Justice Sharan Bobde told the lawyers that unless the protest ended, the Supreme Court will not take up the matter. Protest ended long back. 7 years have passed since CAA, but the Supreme Court has still not decided the matter. Legal scholars have termed this as judicial evasion on the actual constitutional questions, of which many examples can be given. Take the CAA first. Passed in 2019, it fast-tracked citizenship for non-Muslim migrants from neighboring countries, but faced constitutional challenges on the grounds that it violates the secular fabric of the Constitution and Article 14. However, the Supreme Court has repeatedly adjourned the matter, refusing to stay the implementation of the Act or the rules. Consider the next NRC, or the National Register of Citizens. Its rollout in Assam, I hope that many of you must have read about it, was supervised by the Supreme Court itself. The final updated NRC published in 2019 for Assam resulted in the exclusion of 1.9 million people. Ultimately, though the state government has said that it will not recognize this NRC, or the Comptroller Auditor General also said that it will not be recognized by them. Why? Because there were not many Muslims who were included in this exclusion. But unfortunately, there are some basic issues with the conduct of the process. Normally, there would be appeals and petitions why there is this process. But the Supreme Court, if the Supreme Court itself supervises the process, where does an appeal lie? This prompted many scholars to call the Supreme Court an executive court. Gautam Bhatia wrote a beautiful piece on the rise of the executive court. This is what he described the Indian Supreme Court. In fact, no clear framework is provided for the excluded ones, 1.9 million people. They were asked to approach foreigners' tribunal. But these also have access in due process. Recently, the Supreme Court set aside a batch of 27 Gujarat High Court orders that had mechanically upheld declarations of individuals as foreigners, remanding them back to the tribunals. The Supreme Court observed that questions about citizenship and foreigner status must follow a fair, lawful, and reasonable process. But what is this process? There is no clarity. In the third piece of the citizenship puzzle, we have the Spatial Intensive Revision or SIR process about which you must be reading during the elections in West Bengal. The SIR issue began with the Bihar elections in 2025 when petitions were filed before the Supreme Court alleging mass exclusions and screening for citizenship. The court judgment came only 1 year after. Meanwhile, the SIR has continued to expand to multiple states, notably in West Bengal, where the Election Commission deployed a unique policy of detect and delete. It's a new theory invented by the Election Commission, which said that they will detect some flaw in that name of that particular individual in the voter's list and it will be deleted. And it's a very questionable criteria. The results were extremely arbitrary and practically resulted in indiscriminately mass deletions of voters from electoral rolls. The court, instead of pausing the SIR exercise, merely asked the ECI to be fair and flexible with verification. Now, what happens thereafter? When matters got really unmanageable and appeals against deletions grow out of hand, following orders to this effect from the court, 19 appellate tribunals staffed by serving and retired judicial officers were created in West Bengal to hear appeals under the SIR. In effect, millions of citizens, almost 12% of the state's population, were asked to approach these ad hoc arrangements just before the elections, just maybe a couple of weeks before the election. Recently, it was submitted in the Supreme Court by the officer appointed by the court that only 38,000 appeals have been disposed of 34 lakhs cases filed in the West Bengal. A former Calcutta High Court Chief Justice appointed on the SIR tribunal, who eventually resigned, said it would take 4 years for clearing the Kolkata appeals only. This was after he had cleared 1,717 appeals, 77 appeals in 22 days. He accepted all the appeals, or not a single appeal was dismissed. So, what is the situation we are in today? Lakhs of appeals are not decided. There is no deadline for the cases to be decided, and no interim voting rights granted to those whose appeals remain pending during the elections. In May 2026, in its judgment, the court upheld the validity of the SIR process. The court also said that the Election Commission was empowered to inquire into citizenship for electoral purposes, but that this would not amount to a final determination of citizenship under the Citizenship Act. It added, now this is the important part, it added that cases pertaining to names of persons excluded on grounds of doubtful citizenship must be forwarded to the competent authority for final adjudication. But the next question emerges, who is the competent authority? What is the process or framework for its functioning? Amidst all this, the poor and undocumented have been seriously affected. Already, state governments are now using SIR deletions to deprive people under the public distribution system and other welfare benefits. So, even if the Supreme Court maintains that voters' list deletion does not amount to loss of citizenship, where does someone whose access to welfare, basic welfare, has been cut off turn to? The latest clarification. Now, this is very interesting because all of you hold passports, because there are hardly 6.7% people who hold passports. Now, the latest clarification is that the passport is not a proof of your citizenship. In practical terms, a valid passport is treated as proof of citizenship when entering India and also when entering another country. The issuing authority is the Passport Seva Program Division, which operates under the Ministry of External Affairs. Not the, the process of obtaining one involves considerable scrutiny, authentication, collaboration to say the least. A host of documents must be submitted and their veracity examined. Police verification must be conducted. After all this strict checking, if the state turns around and says that the passport is not proof of citizenship, what is it getting at? It doesn't trust its own verification purpose. That it does not believe in the authenticity of identify documents issued by itself. This is arguably, in my opinion, nothing short of an assault on the very concept of citizenship. All of this raises a host of questions. For examples, crores of Indians do not have the kind of documentary evidence that is being asked for under the SIR today. Is shifting the burden of proof on voters already on the rolls of to re-establish their eligibility unfair for marginalized or migrant workers? Worse still, does removal form an electoral roll automatically deprive someone from access to social welfare, subsidies, and benefits? Also, where there is the administrative due process and corresponding accountability in this SIR process with short compliance schedules. For example, when the Supreme Court created this tribunal, the West Bengal elections were only 2 weeks away. How can you ensure that the people are given adequate notice and fair opportunity to challenge elections before election? What is meant by vague terms like logical discrepancy? That's a standard stand taken by the ECI that there is a logical discrepancy. How can this be consistently interpreted at all levels of reverse redressal? So who is going to decide what is logical discrepancy? Whether the appellate tribunal are decided over by judges? Now there will be difference of views. What is logical discrepancy? Given the real implications of the SIR on vast numbers of our population, should the Supreme Court have expedited its hearing on the matter and perhaps consider directing that the SIR exercise be postponed till there was greater clarity on procedure and definitions? Surely there was no great hurry to conduct the SIR. At the end of the day, I don't have the complete numbers, but I just give you a sample. What I got from the record. In Bihar alone, 65 lakh voters' names have been deleted. In the second phase, across 12 states and union territories, including West Bengal, Uttar Pradesh, and Tamil Nadu, over 10.2 of the electoral list was deleted. 10.2%, I'm sorry. The third phase is ongoing in 16 states and 3 union territories, with reports that 6.4% voters' names have been deleted in draft lists for 5 of them. All these people whose names have been deleted or at the risk of deletion have nowhere to go right now. There is no remedy. There is no tribunal or the court where they can go. As fellow citizens, now as human beings, we should be really worried on this aspect. Following close on the heels of citizenship is personal liberty. All freedom rights are centered around this, with an important principle in criminal law supporting it. Bail is the rule, jail is the exception. Today, that rule has been completely inverted through special laws like Unlawful Activities Prevention Act and the Prevention of Money Laundering Act. The state has created statutory bars against bail, effectively ensuring that incarceration itself is the punishment. One of the most publicized detention has been that of Umar Khalid. He has been under trial for 7 years. While some of worst kind of offenders, including violent murderers, are granted bail or revisions with remarkable skill. There is one bad man in North India who is given life sentence and is out of jail at every election or every important event, and is given a revision. So everybody is granted bail, but political dissenters like Khalid languished behind bars. Worryingly, court did not take this matter expeditiously, either or, adjourning the matter or judges recusing themselves or dropping the case from the causes. Fortunately, there are some glimpses of hope. A bench of Justice Nagaratna and Justice Goyan recently reaffirmed that the judiciary's core duty is to protect personal liberty, and that bail is indeed the rule and jail is exception, even under the UAPA. They also expressed reservations about the verdict of another bench denying bail to Khalid and Sajid Imam, observing that it appeared to dilute the binding precedent laid down by a larger bench in the case of Union of India versus K. Najib. Here I am also reminded of a comment made by Justice Ujjwal Guyan. He recently spoke in Pune University, and he said that some judges today seem to be more executive minded than the executive itself. While there are definitely some independent minded judges all over India, we should be worried that this number is shrinking by the day. Justice Abhay Oak, retired, is another judge who has consistently demanded strict procedural safeguards in wide body of his bail jurisprudence. In landmark PMLA judgments like Tarsen Lal, Justice Oak held that once a special court has taken cognizance of a case, investigative agencies like the Enforcement Directorate cannot simply arrest a person unless authorized by the court. But also the Supreme Court's word, the Nagaratna and Ujjwal Goyan judgment, there is no guarantee that this is a final word. The our personal liberties vigilantly guarded as they ought to be. I remain very concerned on this. Next, I want to touch upon another aspect that appears to be a threat to the rule of law, which is the use of extrajudicial tools like bulldozer politics and encounter killings. The bulldozer today is a symbol of power, wielded without legal sanction and authority. Here the state acts as all in one, investigators, prosecutors, judge and executioner, and uses literally bulldozers to flatten the homes of accused individuals without trial. Beyond the demolition itself, the lives of entire families and communities are destroyed. Just imagine. I mean, I, I'm sure that this would not, God forbid, it should not happen to any one of us. A demolition of your house is a destruction of the entire family, entire community. And there are very few cases, I must tell you, that there are lakhs of houses are demolished with this bulldozer justice. Very few people would get the relief. I'll give the numbers. From 2019 to 2023, there was an increase of 379% of forced demolition related evictions. 89% of homes demolished in 2022 and 2023 belong to either Muslims, scheduled tribes, scheduled castes, or other backward classes. The Supreme Court did take some action, issuing pan-India guidelines to halt arbitrary demolitions requiring prior notice and accountability. Chief Justice Bhushan Roy gave this judgment and he speaks about it quite often, frequently. But states continue to defy these directions with impunity. So there is a guideline by the Supreme Court which is violated with impunity by many states. Recently, when hearing a batch of contempt petitions alleging that state authorities had flouted directions on arbitrary demolition, the court remitted the case back to the respective high courts, directing them to decide the case within 4 months without recording any opinion on merits. This is despite counsel arguing that victims were picked and chosen. This begs the question, what is the real value of a guideline judgment if the court that issued it is itself declines to enforce it? High courts we have seen keep matters pending, and in the meanwhile, bulldozer victims have lost their homes and their place of shelter. Who will give them the relief they needed? Another concern is the practice of encounter killings. The Uttar Pradesh government in October 2025 presently issued a statement that since the Chief Minister took charge in 2017, there had been over 15,000 encounters and 256 deaths in the state. This reminds me when I was a judge in the Bombay High Court. I ordered an inquiry in three such sample cases, and a principal judge of the City Civil Court presented a detailed report clarifying or confirming the suspicions that these so-called encounters were fake. The matter eventually went to the Supreme Court, which in 2014 laid down 16 principles of encounters in PUCL versus State of Maharashtra. But encounter killings still continue, and encounter specialists are even terrified today. Sometimes, I mean, you are aware of this recent development in Telangana, in Maharashtra, and many other places. What happens is there is a massive public anger and outrage, with people paying for public lynchings and such like. Some encounters happen in such cases also. Occasionally, there are vigilant judges who inquire further. Notices are issued. Then what happens is that the state governments, in order to escape liability, appoint a judicial commission, usually with a retired judge. And invariably, that commission gives a clean sheet to the enforcement official, even though facts of the encounter speak for themselves. You can read the facts of an encounter, and anyone with a simple common sense would be convinced that this is all fake. But still, they escape the liability and they are given clean sheet. There are some exceptions, I must tell you, that like Justice Sirpurkar Commission, appointed by the Supreme Court, not by the state government, which found fault with 10 police officers in a case in Telangana. You recall, there was a rape and murder of a doctor, and then there was a huge public uproar. So 4 people were arrested. They said that they are taken to some collection of evidence, something, and they were all shot dead. So there, Justice Shetpurkar has implicated 10 police officers for intentional killings of the accused. Now, Telangana High Court has taken this report. The matter is not even taken up till now. So all this collectively begs an important question. I'm putting this question before you. If the rule of law is to be replaced by bulldozers, encounter squads, and government commissions, what role do courts and judges play? Why do we need judiciary if this is to be replaced by these encounters squads and bulldozers? Now I come to the next aspect, which is again very important, that is free speech. This is aspect of civil liberties considered the condition of free speech today. Historically, the Supreme Court has upheld the idea that the freedom of speech and expression is closely linked to democratic ideals and that free political discussion facilitates public education and enables the proper functioning of the court. It has highlighted the importance of respect for and tolerance of a diversity of viewpoints for sustaining a democratic society. It has also implicitly held that the state cannot prevent open discussion regardless of how hateful such discussion was to the state's policies. Surely, the best way to counter criticism is not to shut it down, but to engage with and respond to the speaker. But this seems to have been forgotten by the powers that be in our country today. Unfortunately, today, all kinds of laws and tools are being used against activists, dissenters, political cartoonists to silence and harass them. If a collective of young persons demands the resignation of a politician, demanding accountability, they face criminal FIRs and lathi charges. If media houses are critical of the incumbent government, they are slapped with tax cases and financial scrutiny. Even if years later, after intense harassment, there are finally granted release. There are many news houses which are now cleared. They said that the allegations were completely baseless and they were harassed for years together. Elsewhere, someone mishears a stand-up comedian. This is becoming very common. Someone takes offense, and the next thing you know that the comedian is in jail. Even if you are the organizer of the event that hosts such a comedian, you are thrown in jail. It can be weeks, if not months, by the time you actually get out. Citizens are routinely deprived of basic communication whenever the government perceives a threat to itself. and internet shutdowns have become quotidian affairs. Ask residents of Jammu and Kashmir and Manipur. We have the world's highest record. It should be always remain in Guinness Book of Record that we have the highest number of internet shutdowns in this country. Even in Delhi, recently mobile networks were shut down for a while. Recall also the state's attempt to appoint the executive-led fact-check units under the information technology tools, effectively to censor online criticism. Although this was later shut down. If you think these are isolated instances, some numbers might make you think again. According to the activist group Free Speech Collective, they have made a survey. In 2025 alone, 14,875 instances of free speech violations were recorded through the year, including 9 killings of 8 journalists and 1 social media influencer. 117 arrests, including 8 journalists and 11,385 instances of censorship, and 208 cases of mass censorship and criminal complaints lodged against multiple persons. Journalists are particular targets, particularly those who report on local corruption, illegal mafia, illegal mining, liquor mafias, and administrative criminals. Today, counter-terror laws are being used to suppress the media. There are too many such stories, and I'm sure that by the time you continue to read in the newspapers, you will get simply numb to it. People will stop feeling for it when you can see all over that there is a complete separation of the free speech. Collectively, all of these point to a strategy and a deliberate push towards state monopolized discourse. There is a chilling effect across free speech today, and unfortunately, courts are also reluctant to hear these expeditions. Logically, the court should act as the protector. Instead, we have instances like the NCERT controversy. You must have all read about this controversy, where there was a chapter in the book about about the issues before the judiciary, and the book mentions that the pendency and corruption in the judiciary are challenges to dealt with. As I recall, many former Chief Justices of India have spoken about corruption in the judiciary. Unusually, the court banned the book and sought to blacklist the authors from future academic work with the state. Just blacklisted them, all of them. This order was later recalled. But what is the message? That the judicial power, what the message you are setting to the intellectuals? It would be seen it is becoming positively costly and risky for ordinary citizens, academicians, journalists, and commentators to exercise their basic fundamental rights. It is very encouraging to see some judges like just now there was a mention of Justice Zamdar. I'm very glad that he spoke about it. He said that the peaceful protesting, agitating, or raising slogans against the government cannot be grounds to file criminal cases against them. But opinions and voices like these from the judiciary need to be louder, much louder, in order to be heard by those who need to hear it first. Then I come finally to the secularism and minority rights. Constitutional commitments to secularism are also being impacted. Here I recall Justice Khanna's words again. He wrote that secularism contains no mysticism. It is clear, practical framework where the state eliminates religion from its affair to treat the devout, the agnostic, and the atheist with absolute equality. But what does secularism mean today? Is there a bias toward majoritarian sentiments in the guise of maintaining public order? For example, take the big ban question. This is also relevant for Goa. Can state policy dictate dietary restrictions? Or are such restrictions a violation of personal liberty under Article 21? When majoritarian cultural preferences are codified into criminal law, what happens to the dietary choices, livelihoods, and cultural rights of minorities and marginalized communities? Some glimmer of hope is there, with the Supreme Court recently staying the Madras High Court order that imposed a blanket ban on cow slaughter across Tamil Nadu, but the structural questions still remain to be ironed out. Another facet of this can be seen in the proliferation of state law on anti-conversion. I don't know whether you have seen, any one of you has seen what is anti-conversion law. These are enacted in Uttar Pradesh, Madhya Pradesh, and Gujarat. They share common features. I mean, what are the significant provisions? First, they criminalize interfaith marriages, reversing the burden of proof in cases of conversion, requiring couples to seek advance state permission to change their faith. So, if there is an interfaith marriage, you have to apply to the state government, to the collector first, to seek his prior permission to enter into a matrimony, and even allowing third-party relatives to file non-variable criminal complaints. So, if there is an interfaith marriage, then anyone from the family can file criminal complaints against the couple, and there would be any bail or couple or those supported the marriage. There is enough evidence on the ground that these laws being abused by vigilante groups. With the popular imagination, love jihad, I have heard so much about it. So if you see the facts and figures, I'm seriously questioning. I mean, what is the really proof of this so-called love jihad? But and this you are what we are doing is you are separating the consenting adults, but we have not definitive decision on this. These matters are pending in various high courts and also in the Supreme Court for last, I think, around 5 to 6 years. If matters are not touched at all. Now, another aspect is the fate of the places of worship, Special Provisions Act 1991. This act was enacted after that Ayodhya, the demolition and Babri Masjid demolition. So what this act does is, it freezes the religious character of all places of worship as they stood on October 15, 1947. So all structures, whatever, I mean, it's a Gurudwara, it is a Gurudwara, it will be Gurudwara. If it's a temple, it's going to be temple. It's going to be masjid, it's going to be masjid. So the law is that it would retain that character. The Ayodhya case was an exception, which is provided in the Act itself. Now, the sanctity of this law was upheld, not only upheld, but it was lauded in Ayodhya judgment. With the idea was that we should prohibit courts from entertaining claims based on historical grievances. How long we are going to have these communal disputes? This country has to make some progress, or we are going to be still be fully employed in just communal disputes on temples or masjids or such religious places. Now this happened in Ayodhya judgment. However, the Supreme Court itself abruptly altered this position soon after by allowing a survey of the Gyanvapi Masjid in Varanasi. I believe that the judge who wrote this Ayodhya judgment, and it's a well-known fact who wrote that judgment, also passed this order on Gyanvapi temple, who wrote that this is a constitutional principle that the Places of Worship Act has to be respected. Now, the court noted that ascertaining the religious character of a place of worship was not barred by the Act. So this created a procedural loophole, as now people could ask for excavations, surveys to search for original structures. This has given birth to a spate of communal litigation. I can give two examples, like the Gyanvapi Shahi Jama Masjid in Hon'ble and the Ajmer Sharif Dargah. All are cases in point. Unfortunately, in Hon'ble, there was a huge violence and many people lost their lives. Currently, the matter is precariously poised. The Supreme Court has stayed all further survey-related suits and is hearing the challenge to the constitutionality of the Places of Worship Act. Another dimension can be seen in cases involving questions of religious identity. I was really at pain when I read this judgment of the Karnataka division bench and a single judge, because there is a split judgment on this. There was a question. This is called hijab case. It's just a kerchief to be. It's a traditional ritual for Muslim girls. Now the question was, this was banned. This was, according to me, the simple question of right to education and right to dignity. But after discussing issues of discipline and uniformity, the court upheld the state's position. In a secular democracy, a classroom would be where a child learns to live with diversity rather than shared difference. It must be noted that, as I said, that the Supreme Court is strict on this issue, and in the meantime, the government changed in Karnataka, and this law is vacated. But similar judgment has gone from the Bombay High Court to the Supreme Court. Considering all the facts, I just will have some concluding remarks. I have mentioned so far citizenship, personal liberty, free speech, and secularism. I am concerned as to whether the Supreme Court is not playing its role as a countermeasure and check as it was meant to be as zealously as before. The first thing that stands out is what scholars term as judicial evasion. Major constitutional challenges have been brought before the court on all these aspects of civil liberties. The validity of the CAA, the various state laws, anti-conversion laws, direction of voters, bulldozer politics. But these cases end up in languishing the judicial system, either due to the court not taking the matter in time or redirecting petitioners back to lower courts or tribunals for some other reason. By the time the matter actually gets taken up, maybe years afterwards, it is though fate accompanied has been, has been handed to the state. Take, for example, demonetization. That will take 8 years after the demonetization. Now, whatever is the result, it has, I mean, the policy, such policy and laws under question, they become so embedded in the system that striking it down might become impossible or even irrelevant. Finally, the judiciary is the judiciary failing to protect pluralism in India today? Is a question we should ask. Besides cases themselves, the language of individual judges is also changing. Take for example, a judge of the Allahabad High Court who has since resigned, who besides using derogatory and vile language against the Muslim minority in a public function, declared that India must function according to the wishes of the majority and not according to the constitution. Similarly, a sitting judge of the Madras High Court has also reportedly frequently used language reflective of communal biases. Elsewhere, a Karnataka High Court judge referred to a locality in Bengaluru as mini Pakistan. The Chief Justice of the Madras High Court at a national law school recently suggested that law students should return to their roots and study Sanskrit. Even if they are dismissed as casual observations, these remarks are not mere slips of the tongue. There is also a matter of public spectacle, and I want to mention this. There was a lot of debate, and I want to make this point here. Faith is private, but the publicity given to the Ganpati Puja celebrations at the residence of a former Chief Justice of India in the Prime Minister's presence blurs the line between personal belief and constitutional office, as well as the separation of powers between the executive and judiciary. Justice must not only be done, it must be seen to be done by a neutral arbiter. Surely the sight of the judiciary using the symbols and language of the majority creates a crisis of confidence. In conclusion, I cannot help but bring up the recent wave of student agitation across the country. This agitation goes far beyond grievances towards specific examinations like NEET. They are symbolic of a resurgence of democratic energy. For years, many believed that dissent was fading, civil society was exhausted, political opposition was ineffective, and the space for criticism had been closed permanently. While these young citizens have shown that the democratic spirit in India is still very much thriving, protests were peaceful and principled, with reasonable demands for transparency, accountability, and fairness to the state. In a democracy, they are given. I remember when I was in school, and we were rather surprised. Lal Bahadur Shastri was the railway minister, and there was a train accident, and railway minister has to, and there was loss of lives. So railway ministers were directly concerned with the railway accident happened at that time. Lal Bahadur Shastri straightway after the news was published in the newspapers. He went to Jawaharlal Nehru and tendered his resignation. So that is a given thing in a democracy. There has to be some accountability at some level. So if the youth demands the accountability, they are not wrong. They have every right to demand accountability in any democracy. I would be amiss not to mention the Supreme Court's recent interim orders on the Jantar Mantar demonstrations, where the court held that the right to peaceful protest is a constitutional guarantee that cannot be made with arbitrary state force. Among other things, the court acknowledged the need for a fair and independent investigation into the allegations of injuries during the protest, even suggesting that a special investigation team might be constituted for this purpose. More significantly, the court directed that no courses steps be taken against students provided they have no criminal antecedents, and that personal information and digital data of protesters must not be published for now. So what is happening is now there is a the indication that there would be action against those who shown those records. You not understood this new generation. Perhaps it's beyond the. Some actors said that is what she used some crass words to describe the youth of India. But anyway, but this is a welcome order, and it's precisely the kind of intellectual leadership we need from our judges. By recognizing that the streets, remember, streets, courtrooms, and parliament are all complementary pillars of a living society. The streets are not, you cannot ousted the agitations in the street. To return to what I begin with, Justice Khanna's legacy here becomes important. His career and jurisprudence offer a blueprint for how the legal system rescues its own soul. The health of a constitutional republic rests on whether the legal community possesses the collective spine to stand between the state and the individual. As I touched upon before, this is not the duty of the bench alone. Both the bench and the bar have a role to play. Judges do not need to become heroic activists. They simply need to focus on doing their job independently and fearlessly, maintaining fidelity to the rule of law, principles of natural justice, and constitutional morality. Our future depends on the choices we make today. This moment calls upon both the bench and the bar to step outside their comfort zone and reclaim their role as guardians of the republic to ensure that the promise of Indian democracy remains secure, vibrant, and enduring for generations to come. Thank you.
Thank you, Justice Shah, for the address. You have articulated a subject of profound importance to our constitutional democracy at a time when the preservation of our constitutional values and civil liberties assumes great significance. Your Lordship's reflection on the role of the judiciary have both been timely and invaluable. The address has provided all of us with much to reflect upon. Thank you, sir, once again. As a token of our gratitude and appreciation for your Lordship's gracious presence and invaluable contribution to this lecture series, I request the President of the Goa High Court Bar Association to kindly felicitate Honorable Mr. Justice A.P. Shah with a memento. To propose the vote of thanks, I invite questions and open.
Respected Keynote Speaker, Honorable Mr. Justice A.P. Shah, former Chief Justice of the Delhi High Court, Mrs. Swati Shah, Honorable Justice Valmiki Menezes, Honorable Dr. Justice Neela Bukle, Honorable Justice Sri Amit Johnson Nagar, and Honorable Justice Mr. Hiten Vinigaonkar, Honorable Justice of the Bombay High Court. Learned Advocate General of the State of Goa, Mr. Senior Advocate Mr. Devidas Pangam, respected retired judges present today, senior counsels, advocate colleagues, students of various law colleges, distinguished, distinguished guests, ladies and gentlemen. On behalf of the Goa High Court Bar Association, it is my profound privilege to propose the vote of thanks on this occasion of the second edition of the annual lecture series in the memory of late Mr. Justice H.R. Khanna. First and foremost, we extend our deepest gratitude to our revered speaker, Honorable Mr. Justice A.P. Shah, for gracing us with your august presence and for your enlightening address on guardians of the Republic, the judiciary's role in protecting the civil liberties. Your thought-provoking insights have truly honored the legal legacy of Justice H.R. Khanna and reminded us of the judiciary's vital role in safeguarding the democratic values. We are equally honored by the presence of Honorable Justice Sri Valmiki Menezes, Honorable Dr. Justice Srimati Neela Bogre, Honorable Justice Sri Amit Jamsandekar, and Honorable Justice Hiten Venigaonkar. Your collective presence elevates the importance of this event and inspires us all. We also express our sincere appreciation and respect to the esteemed retired judges who have graced this function. Your continued commitment to the legal fraternity remains a guiding light for all of us. We offer our heartfelt thanks to our senior counsels and the advocate colleagues. Your steadfast support, active participation, and commitment to the Bar Association make events like this a grand success. A special word of appreciation also goes to the law college students in attendance today. Your enthusiastic participation is commendable and engaging, and such profound judicial thought will undoubtedly shape your journey as future legal minds. I must also thank our President, Senior Counsel Mr. Goel Pereira for his guidance and leadership, and our Secretary, Advocate Shivan Desai, and the entire managing committee of the High Court Bar Association for their tireless effort in organizing such this lecture series. A special thank also I also extend special thanks to the learned registrar admin, registrar judicial, and deputy registrar, and the protocol officer of this honorable court for helping us in this function. Finally, our heartfelt gratitude goes to all the members, dignitaries, and guests who took time out of their schedule to participate in today's event. Thank you once again and have a wonderful evening.
Yeah, shit. That's a tension.
And task end करो.
हाँ, सामने करो ना सर. आप सुरक्षा के मशीन पर